It's March 14th, 2026, and this is the Court Gallery. That's right, ladies and gentlemen, it's Pie Day, and we have 4 wild slices of pork pie you do not want to miss. First, we have a neighborly drama that boils over with allegations of flashlight blinding and rock throwing. Then, we have a sentencing for a creep caught intoxicated with a minor in a high school. After that, we see a strange custody dispute where it's revealed that mom's new boyfriend is in a prison? What? Finally, we have a chaotic compliance docket from Yelm, Washington, featuring late arrivals, no-shows, and hefty bail for repeat violators. Grab your coffee, get some pie, and buckle up. It all starts right now.
All right, so next we're going to have sort of a combined hearing, which we are able to do under the procedural rules given the totality of the circumstances here. So we'll call Ms. Fisk and Ms. Hollis, who had filed 2 separate petitions, both against the same respondent here, Jeffrey Rizvet. So I'd ask the petitioners come here, over here. There's two seats here. On my right, your left, and Mr. Is it Rizvet? Mr. Rizvet, is that how I pronounce you? Yeah, here on the left. Okay. All right. So I appreciate everyone's patience. I understand the hearings can go a bit long when there's interpreter services needed. So hopefully, we can not keep folks here for the rest of the morning. And I won't go over the ground rules again. So what we'll do though is, I don't want, I don't want Mr. Rizvet to be sort of inundated with things he'll have to respond to. I've reviewed everything. My understanding is largely that the petitioners are alleging some similar activity, and that there's at least one incident that all parties are really stressing as something that was a catalyst for these hearings today. So I think just for simplicity's sake, I'll allow the petitioners to go. Each of you provide testimony, and then I'll ask Mr. Rizvet to respond. I'll also make a note up front. I understand that there's been a number of folks in the community who submitted letters on behalf of the petitioners. I have reviewed those. I'm not considering those as part of my decision. The rules do require that declarations be sworn under penalty of perjury. There's some specific statutory language that is required for that. So I'm not able to consider those. For what it's worth, witness testimony needs to be necessary and material to the outcome of a case. And so while some of those letters, I think some folks expressed their feelings about what's going on here, I wouldn't really consider them anyways part of this case. So I want to make that up front. So for the petitioners, if you want to just stick to what's in the petitions, I know Mr. Rizvet has, in his response, did ask that a number of materials submitted by petitioners not be considered. I'm not going to consider the letters. I do think it's fair to consider, though, some of the pictures and videos that have been uploaded by both. I know both sides uploaded videos. I think as long as everyone has had notice of those, and I understand we were here last month at a hearing that was reset. So I think everyone's on notice as far as materials that have been uploaded separate from those letters. So I will consider those, and I do think those are important. So without those caveats in mind, which I guess I'll just go here in alphabetical order. So we'll start with testimony from Ms. Fisk. Okay, can you please raise your right hand? Do you swear or affirm the testimony you're about to provide is the truth and the whole truth? Yes. All right, go ahead, ma'am.
I'll admit I don't really know where to start. This has been going on for about 8 months.
Right, and if maybe it would be helpful to refresh as well.
Yeah.
Again, I've read everything. So what I'm looking for in testimony is just a top line summary. You heard me go over the definitions before. What I'm looking for is pattern of behavior. After someone's been given clear notice to stop, that causes substantial emotional distress. So if you want to keep your comments tailored to what I'm looking for there in a more of a summary fashion, recognize I have read everything. And so again, this is really my opportunity to be asking questions. So, but I'll give you that chance to kind of summarize.
Okay. Well, this whole situation has been extremely stressful. I suffer from PTSD, insomnia, anxiety, depression, and all of those have been severely, I don't know how to phrase it. It's affected me a lot. The longest I've gone without sleep is 8 days. I pace around my backyard constantly. I have 3 cameras. I even have a mesh thing that covers my windows because of the constant light shining in my windows and the stalking, or that I have felt that is stalking. He gets his partner to drive around and take videos, photos, play loud music, even before 10 a.m., where most of our neighbors are sleeping. Flip us off. We went on a walk one night, and so this is why I don't walk around the park anymore, because he followed us. It was Tammy, Kyle, and me, and we were walking.
Is this the February 4th incident where the police were called?
No, that was earlier on. I want to say in November. It was one of our first walks since he started harassing us, and we were trying to feel more comfortable. And then so we walked around, and then he's proceeded to turn his light off and follow us, which is, for me, terrifying. And ever since then, I've been on edge, looking everywhere. Like, I don't know where he is. I've walked out of my RV before, and he's been right on the trail right outside. And I don't feel comfortable. Like, I have a dog, and I used to walk him everywhere. I can't even, it's terrifying for me to even leave with him, and I don't know if anything's ever going to happen. So my husband has taken that job on, and I just feel isolated, and I can't sleep. I rarely ever leave my little spot. And no matter how many times we have asked him to stop, we have done it over text, in person. He's even dragged his grandchildren to the food stand that we worked at, and tried to talk to us there with customers around.
So if I may stop you.
Yes.
So when you say we've asked him to stop multiple times.
Yes.
What behavior are you talking about where you've asked him to stop?
For the most part, leaving us alone. We really don't want any contact. We don't want him coming into our areas. We throwing rocks at our sites, trying to hit me with their cars. I can't walk or do anything without being harassed at this point.
Thank you, ma'am. All right, Ms. Haltz, if you could please raise your hand. Do you swear from testimony you're about to provide is the truth and all the truth? Okay, go ahead.
Well, this is, like she said, this has been going on for months. I don't sleep. I don't feel safe walking in the park. I've gotten 2 cameras and a taser gun. It seemed to get worse right after my husband died, and at the end of July. Since the last court date, his girlfriend has been driving by, recording our site, loud music, like 3-4 times a day, flipping off the cameras. She doesn't have to drive by our area at all. I'm scared at night. I don't know what he's gonna do. He's been seen behind my trailer at 3 o'clock in the morning with a flashlight. I don't know if he's gonna set my trailer on fire. And I don't know if you need them. We did bring witnesses with us today. But yeah, I'm scared. I'm having anxiety attacks again. My friend has been staying with me for a couple weeks because I can't sleep. And we've asked him to stop. And there was some sexual harassment. The last incident, he latched onto me and started kissing my neck. And I told him no. I told him no to all of his advances. And then we just told him to leave us alone. But if we even leave our trailer to go for a walk, there he is, no matter what time of day. And he's following us and we're scared. And it's pretty unfair to feel like a prisoner in your own home.
Thank you, Ms. Hollis. All right. All right, Mr. Risvet?
Yes, sir.
All right, over to you, sir. If you could please raise your right hand.
Sure.
Do you swear or affirm the testimony you're about to provide is the truth and the whole truth?
Yes.
Go ahead.
First, I'd like to ask you a question, a procedural question, and make a statement about my evidence. I have a video the night that they attacked me, which was the February 4th night. And I went to the library trying to figure out how to submit my video in a format that the court would accept. I was able to have the librarian help me transfer my video.
We have your video.
You may only have the audio part.
We don't. We have the whole.
You have the video that shows Marcy hitting me. That part.
Yeah, I won't comment on what's it, but yes, I've seen the whole video.
Yes.
Yeah.
So,
audio and video and visual.
I guess that was my point that I wanted to clarify, because I have the video. If you were not able to see the full video, because when I turned it into the court clerk, he said I was able to upload it, but it appears that only the audio.
If it's the incident from February 4th,
Yes.
then yes, we've been able to see it.
So I appreciate that. I appreciate that you have that video. This has affected myself, my partner, and my grandchildren. Obviously, I've heard what they've said, and I appreciate what they say, that they're upset about this. I don't have texts, nor do they. I don't have text because the text that they sent me, the last day that I received a text from Tammy was in August of 2025. That day, I deleted contact with both Tammy, Marcy. I even deleted my dead friend, Jamie. I deleted his name. I didn't need his contact in there anymore either. But I deleted those contacts. I thought I archived the messages. They went to my cloud, and I received a notice recently that says after 30 days, deleted contacts are permanently deleted. I can't even bring those back up. I wish I could. I have no idea how to get those from the cloud. And if they do have texts from my number, I would like to see those. I haven't seen that evidence at all that Tammy has talked about.
I don't think there's been evidence on either side of texts.
No. My other statement, and then I'll talk about how I feel. My other statement is, and I appreciate the fact, Your Honor, that you're not allowing testimony or sworn statements, unsworn statements. And, you know, as far as I'm concerned, Your Honor, you can go ahead and allow them, because really all they contain is hearsay, moral judgments, and people's personal opinion. And I think that you may have addressed that. So really, they have no evidence. There is no evidence. The pictures and video and everything that they're going to show shows prior planning on their part. It shows a conspiracy. And it shows actually that they waited. They had the opportunity not to assault me. and they still chose to do so. The video evidence that I submitted contains harsh language on both parties, from them and from me. What it doesn't show is me yelling and screaming and hollering, because that didn't happen. What it shows is Tammy saying, "I'm not drunk." I didn't realize at the time. When I listened to it again, it occurred to me and I realized what she meant. And so I'm going to have to accept that as the truth, that she was not drunk. But what that tells me then, Your Honor, is that she was fully aware and fully in control of her faculties, that she knew what she had planned, that they waited for me, as another video will show. She was fully aware that what she was doing was wrong, and they continued to do it, and it ended in an assault. From that point, they have lied. They've lied to the police. I'd like to point out a statement that Marcy made in her sworn statement, or in her statement, where she says, "I must have somehow convinced the police that she was violent." My rebuttal to that would be, I don't think I convinced them. I think when the police saw my video, that convinced them that she was violent. I've not included all the evidence that I was able to uncover, because part of it, I think, it happened so long ago that it can't really reflect on true personalities. But I did discover that there have been protection orders filed against the other party. I've discovered that one of them has gone to prison. They want to talk about my past bad acts from 25 years ago.
Right. And so let me just kind of focus in here. So I'm not looking at past acts. The rules of evidence don't apply. I am able to take a broader view of things.
Thank you.
But maybe this can kind of help here. So it seems to me the allegations kind of fall into a few buckets. And I'll kind of address the ones that I think most likely fit into an order, but I'll let folks respond. And the first one is the allegations of shining a flashlight into the petitioner's home. So, that's clear in the petition. There's been some still shot photos that I'll ask the petitioners to sort of explain how they know that's what makes them believe that to you. But so I want to start there. Do you have any response to the allegations that you've been shining a flashlight into their homes?
I do have. First, I don't do that. Second, if I do walk around at night, I do carry a flashlight, as most people do. And in fact, I think one of the suggestions that Miss Rita has posted is that we carry flashlights after dark.
Yeah, and I'm speaking specifically about shining into their.
No.
Okay. So, and what I'm going to do here is kind of go back and forth on specific instances. We stay focused a bit. And whoever wants to speak to this, everyone's under oath at this point. So do either of the petitioners want to address allegations that specifically Mr. Resvet is shining flashlights inside your house?
I've had this happen a lot. It did die down a little bit until the last power outage, and I don't remember the exact date we had that in that area. But right after 10 is when he first showed up, or showed up again after a little bit of not doing things. And so this is when we started going to the office, and they started telling us that we needed evidence and stuff. So we did stand out there from time to time with cameras, or with our phone. And then we bought cameras because we're not outside all the time. And then I found out, because of the bright light he keeps, my cameras aren't registering him when he walks by, and I don't really know exactly what that has or why that is. So
When you
now
say
I have a
bright,
light.
when you say bright light, do you mean his flashlight or a bright light coming from his home?
No, his flashlight.
His flashlight.
He has a really bright light that reaches pretty far and that lights up my entire RV at night, even when the lights are off.
Okay.
So I'm like, I do know it's him. He's the only one that has done it. Even when we were on friendly terms, he would repeatedly do that, and I asked him not to.
When you say that, do you mean using the flashlight generally and it's just so bright it's lighting up your home, or do you mean pointing the flashlight at your home?
Pointing the flashlights directly into my window.
Right.
Not just, I mean, they have been down my pathway as well. Like he stands at the end of on the road and flashes it down there. And that is why there are some nights I have been outside waiting for him to either throw rocks or shine lights or come into my area. In which we have been told by the owner herself to get cameras and to record him if we can.
Ms. Hollis?
I've had the same problem with the flashlights, and you can look out and see that it's him by his dog and his, his light's really bright. You can tell that it's him. And since we put up the cameras, it's been starting to happen behind my trailer instead of out front, because you can see the camera lights in the windows.
All right. And again, I want to be specific because I recognize this is at night. I imagine there's not a lot of light pollution where you all live. And so this is, you're alleging he's shining it directly at your home.
Directly
not just
into my
using it out
windows.
on the road.
Yeah, just all over my trailer and all of the windows.
All right. And then, so I'll keep with the two of you, and then I'll return to you, Mr. Resvet, as next. You've alleged that he throws rocks at your residence as well. What makes you believe that's him? How often does this happen? Have you asked him to stop?
Well, because when we were on friendly terms, he had jokingly was like, "Oh, I've been doing this to so and so's trailer and blah blah." And at first we really did think it was a joke. Most of the stuff he said, he seemed like a jokey kind of person. And then we found out a lot throughout the time of knowing him that even though he's joking, he's actually serious about these jokes. And so there's been times that I've been outside in my backyard and he's walked by, and then I'll hear something hit my car. And I'm like, oh, well, there's Jeff again. And I haven't been able to catch him on camera, but I have on one of the videos. It wasn't a very great video, but you can hear, it sounds like a large rock the night that we petitioned and went to court, like the first one, not the last one. Him throwing a large rock at my RV. And since then, he's been doing it to her. And I have also since then, I've gotten a camera for my back area because I don't have any vision back there.
Right. And again, your belief that it's him is sort of the timing of the petition.
I've seen him. I haven't been able to get him on video. And the few videos I do have doesn't have any, it's dark.
That's okay. I'm really, when I'm asking about this, I understand you all have videos up and that's fine. Your live testimony works too. So what I'm really looking at is if you've personally observed the things that you're alleging.
I have.
Yeah. Okay. Both with the flashlight and the rocks.
I definitely have.
Yeah, and there's one of our witnesses that came today. He was throwing rocks at her trailer as well. So we knew that he did that, and she had caught him doing it, saw him through her window.
And so, Ms. Hollis, you're also saying you personally witnessed
Yes.
Mr. Resvet shining the flashlight and throwing the rocks. It's not just based on after the fact kind of this. Okay. All right. Any damage to your property or cars, homes?
Not yet.
Okay, so it's just you hear the rocks.
Yeah, and then you'll see him walking away.
All right. Mr. Resvet, your response. You can talk about the flashlight allegations,
Sure.
the rock allegations.
Yeah. Well, I have right now probably 4 of my own flashlights in the trailer and 2 flashlights for my grandkids. And I do have a rechargeable light that has a pretty bright beam, but I can't adjust the spot to make it small or large. It's one size. And If I have that flashlight pointed right down the road, the beam is so bright that it'll illuminate the sides of the road or like the little shoulder of the road.
Yeah.
But I'm aware of flashlight etiquette, and I think most people are also. And I know I've talked to Max about that. Max is one of the co-owners. We've talked about flashlight etiquette. In fact, he even asked me about flashlight etiquette, and I observe flashlight etiquette. Something I even have helped my grandchildren learn about, which is we try not to shine our flashlights in people's property.
Can you speak to and I know you've denied the flashlight incident.
Sure.
I think I haven't. Can you talk about the allegations of throwing rocks?
Well, it's untrue. My perspective and my point of view and what I have witnessed, and I'm sure it probably had happened long before I had lived there. I was over at Marcy and Tammy's. I'm sorry, Your Honor. I was at Marcy and Kyle's house one night. And we were getting ready to go back to my place, I think, to have a fire or something. But we were getting ready to leave. We had all been drinking. Marcy was intoxicated. And she reached down and picked up and threw a rock at Shannon's. And I said, "What are you doing?" First off,
Okay, well, I want to just, if you're getting to something related to the current allegations, that's fine. But I want to keep it on
sure.
more recent. They're alleging you throw rocks onto their lots.
I think that I was just trying to respond to what they had said and trying to show that it's a projection onto me of what they actually do. But really, there is no, I mean, I could summarize and get to the bottom line. There's no video of me throwing rocks at people's house. There's no video.
And I don't need the video. They're saying they have seen you do this. And so
Yes.
is it just sounds like you're just flat.
Okay, I see. Yeah, it wasn't me, Your Honor. In fact, Marcy is the one who throws rocks.
Okay. All right, back to the petitioners. You've alleged that Mr. Resvet has been onto your lots, separate from the road walkway, but on your lots, and refused to leave after being asked to leave. Can you talk? Can each of you talk in turn about that?
The night of the police call, he refused to leave, and I was already on the phone with Tammy before he came down. She knows I've been pacing my yard trying to get him on camera because it's very hard to get him on camera, it seems like. So she came over because we saw his light flashing. And so we waited right next to my car, which at the time my husband was gone. And our areas were we parked one car and then another car and then my RV. So it's like a decent space. So we were far away from the road. Anyways, we were talking. We knew he was coming. At that time, I didn't think I needed to record. I usually waited till he stopped and started flashing his light to start trying to record. But anyways, he was walking up the road and Tammy and I were sitting next to my car. He started coming in. Well, first he noticed us. He seemed surprised. Then he came at us and we were like, leave. There's no reason for him to be in my area.
Okay, and this was happening on your lot?
Yes, in spot 60. We did submit a picture of two pictures of the maps, yeah. And he refused to. At that point, we did start yelling, leave, and I got my phone out and started recording him. And at that point, he's backing up into the road. Mm-hmm. And you can see at the beginning of the video, him backing up and then getting his phone ready to record himself.
Prior to that incident, had he been on your lot and asked to leave?
Yes. He has, in the beginning when we didn't want anything to do with him, at some point I had been trying to find a way to distance myself. And I thought I was lucky because he was like, well, I need space. And I'm like, cool, then leave me alone, And after that, he started kind of coming up to me, apologizing and stuff. And I'm like, I don't want anything to do with you. And so one day I believe he was dropping off my grinder and it's still sitting on my steps in a little bag he put it, because I don't understand why he would have done that. But we asked him to stay away from us and to not walk into our area.
We meaning the two,
My husband and I.
you and your husband. Okay. All right. And Ms. Hollis?
I've also asked him to leave me alone, stay away from me. And it's like every time you turn around, he's walking by or he's standing somewhere close by you, videotaping you. The incident on the video where he claims to be assaulted, you can clearly see me getting in between him and Marcy because he was grabbing at her.
And I want to stay away from the video and just, I'm thinking, I want to know more about prior
He came in
communication about not wanting contact, not coming onto your property.
right after my husband died. He came over and we were trying to talk to him about his inappropriate sexual things that he was saying and doing to us. So he was on my site then, and we made it quite clear that he needed to stop and leave us alone, and we didn't appreciate the comments or being touched. And there was another incident.
And let me just, when you say not appreciated, I understand that. Again, as I kind of said at the beginning, what I'm really looking for too is comments that are not appreciated, but then notice to the person to stop communication, to stop unwanted behavior. In addition to being something you may not have wanted, can you talk about communicating that to him?
He was told several times and he didn't know what the word no meant. He doesn't listen. And we've complained to the office and they keep telling us to get him on camera. And now he's just, every time we see him, he's recording us. And now his girlfriend's driving by recording our trailers for no reason, just harassing.
All right, Mr. Resvet, over to you. Specifically with, again, I'm looking at allegations that you've gone onto the property of the petitioners after having been asked to not go there, and speaking with them, having physical contact. I think Ms. Hollis indicated that after being asked not to. So if you want to address those.
Sure. I have not spoken directly to them until the night of February 4th. I've not spoken directly to them since probably August 7th or 8th. I can tell you the comment or the conversation I had with Tammy on August 5th, her birthday and my girlfriend's birthday.
Is this a time when you're around when you may have expressed to him not to talk to you after that?
That was a couple of weeks before one of the incidents where he latched on, started kissing my neck, and it was 5 days after my husband died. So I may not remember that entire conversation.
Okay. All right, I'm just trying to get a
But
sense.
he was told to leave me alone.
Okay. All right, go ahead, Mr.
The night of August 5th, when I went over to talk to Tammy, I had texted and said, I want to come over and talk to you. And the reason I wanted to come over and talk to them is because my girlfriend, my wife, I call her my wife, but my girlfriend and Tammy share a common birthday. We went out to dinner. Unbeknownst and coincidentally, Tammy and I think her friend's name was Edie, had gone to the same restaurant. I didn't see her. My daughter did. She said, why is Tammy staring at us from the checkout counter? I said, what? I grabbed or took one of my grandchildren out, and my daughter took the other grandchild out to try and see Tammy so we could say, hey, happy birthday. Hope everything's going well. Happy birthday. Didn't catch that. So but I knew that Tammy had seen me. I wanted Tammy to make sure I wasn't ignoring her. I wanted Tammy to make sure that I recognized it was her birthday and to say happy birthday. When they say that I was asked to leave and I didn't want to leave, Tammy at that time told me 2 months after our initial, when she claims that I initially started making harassing comments to her 2 months after that. And I thought we had talked about it. Everything was fine. I'm the type of guy that goes on. I apologized. We go on. 2 months after that, on August 5th, Tammy told me that she was still holding a grudge, that she was still angry about the way that I had acted when I was deep in my throes of alcoholism, that she was so angry that she couldn't forgive me 2 months later. At that time, I said, my mom treated me like this. I don't accept this kind of treatment from people. If you cannot forgive me and go on, and 2 months later, you throw this in my face, I said, we don't need to be friends. And I attempted to leave. By that point, Marcy had come over. I think Tammy had texted her, Jeff's being mean or something. Marcy had come over. I was leaving. I was attempting to leave her property, Tammy's property. She got up, she held on to me. I said, Tammy, get your hands off. Marcy was in the background, and I heard Marcy say, Tammy, just let him go. I had to physically take Tammy's hands off my arms so that I could leave. I've had no further contact. Let me amend that, Your Honor. A few days after that, my grandchildren were coming over. My grandchildren loved Tammy and her husband, Jamie, and my friend Marcy and Kyle. They loved them. Marcy and Kyle used to come to the playground and play with us. They'd meet us downtown at playgrounds to play with us. After August 5th, I did approach Tammy and Marcy at their stand, at the food stand. And I said, the kids are still asking about you. I want to let you know that the kids are coming over tomorrow. I want to pay for their cotton candy today and the tip so that we don't have to deal with this tomorrow. I can just have the kids come up with somebody else, with Katie, somebody. Here's my money. They took my money. The next day, I went up just to make sure that everything was going to be fine. Tammy was there, and she said, Marcy's not coming in today. You know, I was disappointed. I knew my kids were going to be, the grandkids were going to be disappointed.
So this is around August?
Yes, August, probably 8th or 9th. I know it was after her birthday, a few days after her birthday.
So it sounds to me like around this time in August is when I'm kind of hearing there was some clear expressions to not speak with the petitioners, not to go into their property, turning back to the petitioners. So now we're looking at sort of that August forward. At this point has looking at that time frame, Mr. Rizvet communicated with you, gone onto your lot, things of that nature since August 5th. Okay, both indicating yes.
Yeah.
Can you give me some examples?
Well, I don't know if this is exactly very helpful, but at some point when we take our dog on a walk every day, but I stated that I felt uncomfortable. I usually go there's a camping area that's completely empty when it's like in August further on because, well, it's too cold. But anyways, we walk around there and my husband ended up taking that job for me. And he's Rizvet went to the office at some point, was saying some stuff, and then proceeded to tell the office that he was going to call my husband's job. And then he proceeded to walk around the tent area one day, and my husband was trying to ignore him. And he was like, I called your job, I'm going to get you fired and stuff like that. And that harassment, little comments and little like throwing rocks at our RV, walking by, staring us down, this creepy smirky smile that he does a lot.
How about comments sort of directly at you? Has he talked to you since
then? I have
onto your property?
gone out of my way to ignore him. He has tried to apologize from time to time, but I literally I don't say anything. I just keep walking.
Okay. All right, Ms. Hollis.
I've seen him veer off of the road intentionally and walk in my driveway. Where we live, the campsites are kind of back to back and you have empty spots on the sides. And he feels it's okay, even though they're really close to our trailers, to walk in and out of those with his dog, which makes us both very uncomfortable because it's right next to us. And he knows, I believe he knows what he's doing.
All right. Last thing I want to cover here is there's been allegations, Mr. Resvet, of you from the main road, it sounds like, filming them.
Yes.
What are your response there?
I have done that, Your Honor, because I felt like almost a tit for tat, and I know that's immature. But they want to say that I keep walking around their area, that I walk in and out of their neighbors' campsites. Tammy has neighbors on both sides of her. They're not empty sites. Sure, her neighbor on her south side has been there as long as I have, I think, Your Honor. Those sites are never unoccupied. But yes, I do videotape them because I wanted to be able to show that since I'm not walking around there, and Tammy has said this to me, stay on your fucking side of the campground. Since I don't go over on their side, I wanted to videotape them walking by my house repeatedly. I don't go down the center road behind their house because I think it's too close to their house and I don't want them to say, oh, Jeff's harassing us. But I do notice that there have been times when their neighbor across the street drives by my house and 5 minutes later, they're walking down the road behind my house, laughing and talking and blowing bubbles. So yes, I have taken pictures of that. I did take a picture, a video one day when they were standing out in front of the shower and I was wanting to go down there and could not go down there because I didn't want to come face to face with them. So really, I mean, they want to say I shouldn't be doing this or I shouldn't be doing that. I take videotapes to show that they're doing what they want me not to do. I do have a rebuttal statement for something that Marcy said about her husband, Kyle, and I know he submitted a statement, so I did want to talk about that.
Okay, so I'm not considering that because he's not a petitioner. Okay. I'm not considering that, so we don't have to go down that road. All right, so here's where I'm thinking at this point. There's a lot of allegations, and it seems like, frankly, most of the animosity here is with respect to things that Mr. Resvet is doing in an area where I don't really have any control on the main roads here. Y'all are neighbors. I can't evict him. I can't issue any orders that prohibit his use and enjoyment of his own property. And so I can't tell Mr. Resvet, don't walk your dog at night. Don't, as long as he's on a public road, even if it's at night, even if it's, at times that make folks uncomfortable, there's nothing I can do to prohibit that behavior. What I can do is it sounds like the petitioners have made it clear to Mr. Resvet that they don't want any contact and that they don't want Mr. Resvet on their lots. And so, with respect to that, coming onto their property, having contact with them, I do think that they've met their burden on that front. That there's been an express notice that they don't want any communication. And it does sound like I recognize that there's a lot of friction in some relationships where it sounds like there may have been some friendships before that have soured, and that it is sometimes difficult to understand when exactly no contact is wanted at any point anymore. And it sounds like that may have been the case here, but it does sound like from what has been submitted, and again, I'm just reviewing the sworn testimony and the sworn petition, that there was some communication to Mr. Resvet not to contact them or to go onto their property. So what I'm going to do is I'm going to sign an order prohibiting contact with the petitioners. I'm not going to put any kind of geographical restriction on excluding or staying away from their property because I recognize your neighbors, and I also recognize you have a right to be on the public road. I can't do anything about that. And so what it's going to specify is you're not allowed to go into their property, onto their lots. You can go onto the road, which is not their lots. And you can't have any contact with them, direct or indirect. So no, it sounds like your girlfriend may have a relationship with them as well, or in that, you know, a spouse. So no indirect communication. It just sounds like stay out of each other's business. Don't go onto their lots. Don't communicate with them. I'm not restricting your ability to go where everyone else can go. Sounds like in this community, there's a lot of walkways and areas that are open to the public. Again, there's nothing I can do about that. If you think that he's breaking some of the management rules, some of the rules of the property, you know, that is a conversation for the folks who manage the property. I can't enforce, you know, noise restrictions yet.
What about him recording us every time we drive by? Because it's a one-way. We can't stop from driving his direction. It's and there's two ways to leave, and they're choosing to go our way. So
right. So again, he's able to leave the area the way he wants to. Now, so as far as him filming, you know, number one, and this is not a criminal case here, but it is a crime to record people without their consent. It is different when you've got a Ring camera or something that you've installed, right? Because that doesn't pick up audio, and there's nothing wrong with that. Yeah, I'm still a little unclear as to is the allegations that he is going up to you, either of you in public, and recording you, or is it that he is on his lot recording when you go by?
well, it's both actually. He's been caught doing it in his area as we're just driving by, and the most recent incident I can think of is she was doing her laundry, and she was driving by the field, and he was busy recording her as she drove by. It's a very public area.
Right. Okay. All right. Well, so as far as him recording folks from his property, there's nothing I can do about that. The same as you all having a Ring camera, you know, you're able to sort of, when you're on your property, you're able to do things like that. And so again, you know, audio and visual recordings of folks, when they're in public, there's not much I can do about that. Now, you know, if it gets to a point where you think that this is you being monitored, you know, that could be a different story. You know, that is where you get the legal definition of stalking. It's not just the occasional recording somebody.
I do feel like we're being monitored every day, though.
Right, but it's difficult because you're also neighbors, right? So to the extent that you see him at night walking his dog, that he's recording folks from his property. I mean, you're neighbors. And again, I can't evict him. He's going to be living there. So that's where this gets a little difficult, is you're going to continue to be neighbors.
Well, yeah, we've run into the same problem with the office people. They're hoping for certain kind of things to be able to go through a process.
Yeah, but what I can do, again, where I can act is on somebody's personal space and personal property. And so for that, you know, so I will issue orders protecting, restraining Mr. Resvet from talking to them. Sounds like at this point there's been a clear break. And so there's going to be no communication with either direct or indirect. You know, that includes no physical contact, and exclusion to not go onto their lots.
Sure.
All right.
Yeah, I can live with that.
Okay. Yes, ma'am.
To be clear, does that mean that Katie can't harass us, flip us off?
No.
The girlfriend?
This does not involve her. There would need to be, ma'am, is that you?
Yeah,
of course it is.
Ma'am,
Yeah, and I haven't done that.
okay, but that kind of reaction is not helpful.
Sorry.
Okay.
Sorry.
No, she's not a party to this. And they
Okay.
don't have any kind of legal relationship, it sounds like. So
well, they figured since they live together and they've been together for a very long time that they're both doing it, and I believe that he's keeping track of her.
you would need to petition against her. But again, the order is direct or indirect. So if you have evidence that he's indirectly contacting you through somebody else, that's also a violation of the order. You know, so that's going to be on here. So it's do not attempt or have contact, including non-physical, direct, indirect, through third parties, Period. So, that would, if you think there's indirect, so for you, that's part of it as well, right? Is you can't tell your girlfriend to talk to them or anything like that. Or
May I ask a question?
Yep, one, and then I think we're going to be let folks go. Yep, go ahead.
They've stated that I record them as they come in. They record us as
Yeah,
we
and
go out.
I noted that, and that's why I'm not addressing that
And,
issue in the order.
The other thing is that my wife drives a really small car through. There are 2 exit routes,
right. And you're allowed to use the exit routes.
There's one entrance route.
Right.
Okay, I can't stop them from going past my house.
Right.
I can't. I don't go past their house.
Okay.
I have a big truck. I go up the middle. It's potholes. It's like this. Katie's car sits about this far off the ground.
Okay.
And to go out the exit loop on theirs is the smoother route.
Okay.
It takes an extra minute, but Katie doesn't have to deal with the potholes.
Okay.
But I have one more thing to say. It's not a coincidence, Your Honor. They want me to stay off their property, and I don't go on their property. And I think you've seen on the video that I wasn't on the property. It's coincidental. I can't prove it. They're not the only ones with security cameras, Your Honor, however, but Katie's car was vandalized the other day.
So we're not going to get into that right
Okay.
now. Orders have been issued at this point.
Sure.
They'll be available to folks later this afternoon when I complete them. And if you have
Sure.
any questions, you can reach out to the civil department. All right. But that'll be the order of the court. You're all free to go.
So will that order include restrictions on them also of not contacting me?
No, it's a one-way. You would have to petition against that. All right. Thank you all.
Thank you.
Nope. Everyone stop. Hey, Katie. No.
Stop. You start talking shit
Nope.
to me.
Nope.
Okay.
Stop.
Can I go, Your Honor?
Yeah. I meant stop in the sense don't talk to each other. All right. You're all free to go.
No, I'm waiting for them to leave.
All right.
Sorry, Your Honor. Thank you.
That's all right. All right. Thank you both. All right.
All right, we'll call People v. Joshua Coors. It's filed 26-7127H.
Good afternoon again, Your Honor.
All right, and we've got Ms. Goodrich, prosecuting attorney, present as well. This is sentencing on operating while intoxicated with an occupant under 16 years of age, as is with a second offense notice that makes it a 5-year statutory maximum. The advisory guidelines were scored at 12 to 24 months. And I have received some letters of support this afternoon that I did have an opportunity to review, as well as your scoring challenge. So before we get to the scoring challenge, Mr. Kupeski, do you have any factual additions, corrections, or modifications to the pre-sentence report?
Just 2, Your Honor. The very cover page, the basic information report. It says marital status married. Mr. Coors is not. He is single, so he's not married.
Okay, yeah, and it does, maybe that just populated from some.
I would imagine so, because it's nowhere else in the report, Your Honor.
Since he was married but then divorced in 2021, and the narrative portion of the pre-sentence report accurately reflects that. My guess is that just populated from a previous felony. So Agent Purvis, would you make that change? Okay.
Thank you.
Any other additions?
The only other addition was on page 2 of the report itself, indicating the jail credit. It stops counting days at February 10th.
Oh, and then,
So Mr. Coors is up to 164, I believe. Yeah,
okay.
it's March 10th, so the additional 30.
Okay. Any objection to that, Ms. Goodrich?
No objection.
Okay, so we'll amend that Agent Purvis from the 210 to 310 and jail credit at 164 days then. Okay.
Actually, today's jail list says 165.
165, okay.
Thank you.
All right. Ms. Goodrich, did you have any additions, corrections?
No, yeah.
Okay, Mr. Kukuski, you had a scoring challenge as to OB9. Go ahead.
I did, Your Honor. We respectfully asked the court to change this scoring of offense variable 9. It currently is scored at 25 points to indicate that 10 or more victims were placed in danger of physical injury or death in this case. And that's based, obviously, scoring of that is based solely on the defendant's conduct during the sentencing offense. Now, in this case, he's operating while intoxicated, and obviously other people are on the roadway, drivers are on the roadway. However, there is no indication that he was driving erratically, that there was an accident, or that there was any, the number of actual victims that were placed in harm's way or that he may have passed by. I know in previous cases or cases that I've reviewed, one a guy shot at a windshield, there's 3 people in the car, 3 victims, obviously. Your Honor mentioned a case where some pedestrians got really, driver got really close to pedestrians, and those were counted as victims as well. In that case, we have an actual number, we have an accurate a view of the victims that were placed in harm's way. In this case, all indications in the report and all indications from the officer's finding was that he was operating certainly within legal means, other than his operating being intoxicated. While he was intoxicated and he was pulled over, there was no indication, as I said, of bad driving, swerving driving, or that he sideswiped the vehicle or had any other interaction with anybody that could constitute a victim in this manner, Your Honor. So we'd ask that score be 0 as opposed to the 25. Thank you.
Right, thank you. Ms. Goodrich, people's response?
Yes, Your Honor, I did provide Mr. Kukuski, but just before this hearing, unpublished case, which I understand is not binding, People versus Harris, and I could present it also to the court.
Okay, very good.
It just states that when a vehicle was striking a pedestrian, I point to the court to page 3. Subsection B is OB9. The bottom paragraph just states that in this case, there was evidence at the trial that it was a very busy road, that there were numerous open businesses near the area of the accident, and that the street was labeled as busy with several cars in the video of the accident. And in this case, Mr. Kors was alerted, or somebody had called in, that he appeared to be intoxicated and falling asleep at the wheel. He had his child in his car. He was in the school parking lot, the high school parking lot, at 1500 hours, 3 p.m. And so I believe that it was scored due to it being presumed that there was various cars leaving the school at that time, underage, inexperienced drivers, as well as people walking to their car. Thank you.
All right, any rebuttal argument, Mr.
Just briefly, Ms. Goodrich was kind enough to provide me with that decision from the court. And in this case, there was testimony that the driver in that instance passed 16 vehicles. And so they counted 16 people. He also got into an accident with a motorcyclist and actually killed them. So I think there's a distinct difference between identified victims here, and they had a video of it, as a matter of fact, that showed him passing by other vehicles at a high rate of speed, where in this case, there's no factual indication of anybody who's walking out in the street that day, vehicles that were around Mr. Kors or anything like that that would warrant a scoring. So I think there is a distinction between these two matters that would allow the court to score this at 0 and not the 25 points on an assumption. Thank you.
All right, thank you. Well, OB9 is based upon the number of victims that were placed in danger of loss of life or of injury. And here it's scored at 25 points for 10 or more people placed in danger of loss of life or injury. And the basis for that is that Mr. Kors was operating the vehicle while intoxicated, while he was at the school, while it was being let out at the end of the day, so that there would be a number of folks around including students and inexperienced drivers. That was the stated basis in the PSI for the scoring, and that's what the prosecutors relied on. I think those circumstances could very well support a finding that the defendant's behavior as part of the sentencing offense did place those folks in direct or even indirect danger of injury. Even indirect is allowed for OB9. However, the prosecutor does have the burden of establishing that by a preponderance of the evidence. And here, all I know is that there was a BOL at 3 p.m., at around 3 p.m., around 1500 hours, a BOL for a possible intoxicated driver parked in front of the high school and hammered, drunk, and falling asleep. And then a follow-up said the vehicle had moved and was heading east on Lincoln. I don't have any detailed information about what time the school let out. Where was this vehicle in proximity to the school? Where was this vehicle in proximity to other vehicles? Were there pedestrians nearby? Were there minors nearby? How many were there? I think if I were deciding on a probable cause standard, could I say that he probably placed more than 10 people at risk of harm? Certainly I would. But on a preponderance of evidence, I don't see any evidence. I would guess that there were more than 10 people in the vicinity, but maybe not. Maybe there were only 8 in the vicinity, and that would be a different score. So I just don't see on this record evidence that would meet the burden of proof of a preponderance of admissible evidence. Well, preponderance of the evidence. The rules of evidence don't apply, but there has to be a preponderance of the evidence, and I just don't see it. So I'll sustain that objection and score OB9 at 0 points. That would change the total OB to 10 points and the OB level to level 2, which adjusts the guideline range to, as I see it, 7 to 23 months.
That'd be correct, Your Honor.
Okay, Ms. Goodrich, do you agree with my calculation?
Yes.
Not my ruling. All right, Mr. Kesky, any further challenges?
No, Your Honor.
Ms. Goodrich, any scoring challenges from the people?
No, Your Honor, thank you.
All right, Mr. Kesky, anything you want to say in the client's behalf?
Thank you, Your Honor. I would, I guess, indicate that we have had discussions in chambers that there was a binding sentencing agreement in which Mr. Coors was, the prosecutor offered him a county cap. Your Honor's indicated that he's not going to follow that at this time. After speaking with my client, he is prepared to move forward with the sentencing, understanding that he's going to be held within the guideline range, maybe the top end of those. So with that being said, Josh was certainly demonstrated to me that he's learned a lot from this. I know he's got quite a history. He's been incarcerated and he's been in prison a few different times. I think Your Honor's put him there once. And this matter didn't happen that shortly after he was discharged from parole last time he was on. But he's been attending AA regularly while he's been in that jail. He's been going to service. He's been counseling with the pastor. He shows to me a lot of remorse. He loves his daughter dearly, who was in the vehicle at this time. He understands the gravity of the decision that he made and that he put her certainly at risk. And he, I believe, beats himself up every time I do talk to him about that. He wants to be a father. He wants to be a father to his daughter. In speaking with his daughter, he understands, and she's, kids aren't ignorant to these things. Kids understand these things. And I think she's shown a real ability to, and talking to him, that says, hey, you put yourself in this situation, you put me in this situation, that we're not going to be able to see each other for a while. And that really hurts. And I think Mr. Quarters has shown adequate remorse for that. He's really, I think, in a turnover in leaf. And I just pray that he doesn't continue this conduct. I'm confident that he won't in our discussions. And I'd ask the court to, again, stay in the guidelines. Maybe 20 to 18 months would be appropriate. Obviously, we understand that Your Honor's not going to keep him here in counsel. Thank you.
Thank you, Mr. Kukeski. Mr. Coors, you don't have to make a statement today, but you're welcome to. Is there anything you want to tell me or no?
Yes, sir.
Okay, go ahead and start.
I would like to apologize to the community and my daughter. I know that I have a repeated history due to alcohol use, and I literally tried almost everything I could to almost manipulate myself into thinking that I could do it and figuring out ways to be able to do it. And every time I do, I get in more and more trouble. I never thought, because of the trouble that I've either been in or because of this or anything, that my daughter would ever tell me that she doesn't want to talk to me. Sorry.
It's okay, take your time.
I was doing better since I got out. Actually, now I'm in prison. I got out and I was doing better than I had probably close to 15 years financially, being there, just a lot of stuff. And I know that one choice that I made altered the whole course of everything that I'm going on. And I know that it's very serious. I know that I could have potentially harmed a lot of people, which I don't want to do. I'm really going to take this time to, regardless of what happens, to really get an order of this in front of it. Like, I don't want to keep doing this. My daughter will be 8. And should be 8 on the 20th of this month, and again, I'll be there. So I know if I don't drink, I would probably never be in trouble. So if I fight it's hard to not do it as much as I fought to do it, I would never be here. And I'd just like to apologize. It will not happen again. I just want to make things right with everybody.
Okay, thanks, sir. Ms. Goodrich, any recommendations from the people?
Thank you, Your Honor. This incident occurred on Tuesday, September 29th, around 3 p.m. Call-in came that Mr. Flores appeared intoxicated and falling asleep. When pulled over, he was honest that he had taken a shot around 10 a.m. that morning. A bottle of Fireball was found in his vehicle that was 75% empty. And his lab results were 0.15. Mr. Kors is 33 years old with 5 felonies and 7 misdemeanors. He's been to jail 6 times, prison 2 times. He's been on probation 6 times. We did, upon entry of plea, have a sentence agreement to a county jail cap. The court fairly warned us that the court may not follow that sentence agreement. There has been no misconduct by Mr. Kors since the time of plea, so I would still ask the court to follow the plea agreement. Thank you.
Thank you. Mr. Kors, if you please stand for the court sentence. Mr. Kors, you're convicted for operating while intoxicated with your minor daughter in the car. You have a prior conviction for an OWI offense. That's what makes it a felony here. And although I didn't score OV9 because we didn't have sufficient proof of precisely who you put in danger, your own statement acknowledges that there were certainly people that you placed in danger, and you seem to show an appropriate remorse for that. Some of your notable history here, in 2016, it looks like was your first trip to prison when probation was revoked in Emmett County, got an 18-month sentence. And in 2018, another prison sentence of 24 months for an attempted assault out of Emmett. You were paroled in 2020. Then while on parole in 2021, committed a drunk driving and a domestic violence felony. That's the case for which I had sentenced you to prison for 23 months to 5 years. You were paroled in March of 2024, successfully discharged in June of 2025, but then less than 4 months later committing this offense. You've been on probation 6 times in the past, every single one of them unsuccessful, and had a parole violation to boot. The last 10 years, you've hardly had any period of time where you've been free and not been committing crimes. You seem today that you say that you're kind of tired of that. I hope you are. You know, you're 33 years of age now. So you're kind of at the tipping point, so Mr. Coors. So I'll just tell you, in 25 plus years of just being involved in the criminal justice system in various capacities, I'll tell you, for some reason, plenty of guys in their 20s, not plenty, but there's a percentage of guys in their 20s that cause problems and are in and out of jail or prison. Some of those folks that are in and out of prison when they're in their 20s grow up and change, and they stop going to prison. Some of them, that was just the first part of their life on the installment plan. You're now 33 and going back for now your 6th felony. You're at that fork in the road. This could be your last trip, and I hope it is. If you mean half the things you say today, then get out and get yourself involved in AA and get serious about kicking the alcohol. And then you could be one of those people that we can say, gee, remember when Mr. Coors used to go in and out of jail and prison? Well, gee, he hasn't been in trouble in 10 years. There are people like that in this community. Many of us in this room know who those folks are. We're glad when that happens. But there's also a whole bunch of other people, we can give you a list of names, that they just keep going back and keep going back and keep going back. I have no idea which one of them you are, but we're going to find out together, aren't we? I think given that history, I can't abide the county jail cap. So I think I will, it would be my intended sentence that I think given the risk of harm to the community and the history that I have outlined, it'd be my intended sentence to impose $68 in state cost, $130 in a crime victims assessment, $350 in court costs, $300 OUIL reimbursement, and a $500 fine, and commit you, Mr. Coors, to the Michigan Department of Corrections for not less than 23 months, nor more than 5 years, with credit for 165 days previously served. That is a sentence that does not follow a sentence agreement that you had reached. So you do have an opportunity to decide whether you wish to accept that sentence or withdraw your plea and go to trial with the habitual notice. And I know that we had some discussions before court where your attorney made you aware of that possibility. But now that it's a reality, if you want a minute to review that with your attorney, certainly do that. Do you know right now what you wish to do, Mr. Coors?
Yes, sir.
You don't want to talk to Mr. Kupiski anymore about it? And what would you like to do, Mr. Coors?
I'll do the 23 months.
Okay. All right. So that'll be the sentence imposed by the court. You can file an application to appeal to the Court of Appeals if you wish. If you want a lawyer appointed, you'd have to make that request within 6 months. We're going to hand you a piece of paper explaining that appeal process. Ask you to initial one copy for us so we have a record to give it to you. The other one is for you to fill out if you want to take an appeal. Do you have any questions for me, Mr. Coors? Okay, good luck to you.
This case entitled In the Matter of the Marriage of Amanda M. Benaway and Brian C. Benaway. It's case number 2026 DM3. Jessica Sir appears with Amanda Benaway. Brian Benaway appears separately by Zoom from his attorney, Jennifer Goheen. This matter comes before the court at this time for further proceedings. Ms. Goheen, give me your assessment of the status of this case.
Judge, we are in the position where we obviously don't have an agreement as to shared residency in this case. And so this is our motion to modify the temporary order. And we're requesting shared residency for my client. And we're also requesting a restraining order for mom, preventing her from exchanging any information about the minor children or the family with her boyfriend, who's an inmate at the Hutchinson Correctional Facility. And so those are the requests that I'm making today. To give you a little bit of history in this case, these parties were married July 12th, 2014. They have a son who is 7 and a daughter who is 4. Mom filed this action January 2nd, 2026. My client works for Koch Industries, and makes approximately 90,000. Mom works and is the vice president of clinical services at St. Francis Ministries. She makes about almost 107,000. I do believe we can work child support out. However, the court makes a determination today regarding residency. There's no question the parties will have joint custody. It's just a matter of residency in this particular case. So at present, the party's eldest child attends elementary school in Rose Hill, and I should give you a little more information. My client left the residence and mom filed her temporary orders granting her to stay in the marital residence, which is fine. My client's not objecting to that. Then in this situation, she gave my client more limited parenting time and awarded herself primary residency. My client is living with his parents, and he is living with them he is living with them in Augusta. So at present, their son attends elementary school in Rose Hill. The youngest child attends daycare, and she'll be out of daycare in June, and both children will likely go to camps this summer.
Okay, Ms. Goheen, where is the daycare for the 4-year-old?
It is in Rose Hill.
Okay, go ahead.
And historically, my client would pick up the party's youngest child and take her to daycare and then pick her up on his way home from work. And so obviously now we're in a situation where this divorce has changed things. My client is going to be living with his parents for quite some time until we get this divorce resolved. So what he's requesting is that mom have parenting time with the minor children every Wednesday morning at 8 until Friday at 8. Dad would have parenting time with the minor children every Monday morning at 8 until Wednesday at 8, and they would have alternating parenting time. And this is one of those good cases in terms of these parties do communicate well, and at least I hope that they're both focused on the best interests of the child, and I believe they are. My understanding from mom's position is in this case is that her concern is my client would need assistance to drop off their eldest child at school and pick up the eldest child at school. There's no concern. He will continue to do what he's done with the youngest child. So that's
He personally would?
He would pick up the youngest child and drop her off. He will continue to do that.
Okay, and the older one?
The older one goes to school a little later. So he would have assistance from his mom or dad. They're both retired in this particular case. Essentially what you're talking about is the children wake up at about 6. So my client also is in the position where he said, if I need to, I can drop off the eldest child at mom's house, and I'll continue to drop off our youngest child at daycare. I'll do whatever works for mom. If she's so opposed to grandparents dropping off at school in the morning, then I will drop the child off to mom in the morning. Then the only thing that would be grandparents would pick up after school. And if she wanted him to, I'm sure he would pick the children up, or the eldest child, from her at her house if she really insisted upon having the child at her house. These are grandparents these children are very, very close to. Luckily, these parties have good support systems. And so these aren't people that are unusual. They regularly used his parents to babysit. And so that's not a problem in this case. But we're willing to work with mom on whatever works the best. This doesn't change anything with the youngest child, who he was picking up and dropping off before. It's just the eldest child that we're looking at in this case. I'm not looking at a situation where I have to defend my client as a parent, because there's been no allegation that he's inappropriate as a parent. He is a great parent by all accounts at this particular time. This is also a good situation for shared residency because these parties can communicate. So the only thing that's at issue here based on what mom has filed, is simply the pickup or the eldest minor child going to school and coming home from school. That's it. And so my client is requesting shared residency. The other issue is a restraining order for mom. She began a relationship with an inmate at the Hutch Correctional Facility, and both parties worked there previously. She was a mental health therapist there. My client was an officer. My understanding is mom has shared intimate details with this inmate about the family, including pictures of the minor children in this case. This is an individual who was convicted for ag kidnapping, ag battery, bodily harm with a weapon, ag battery, intentional great bodily harm, criminal threat, ag robbery without authority to enter with intent to commit a felony, theft, or sexually motivated crime. I looked at his disciplinary reports. They are extensive, and there were recent ones as of February of 2026, including dangerous contraband, including with weapons, threatening or intimidating others, incitement to riot, battery, lewd acts, and theft. Even more concerning than that, it appears that this gentleman's father served time in prison for rape, sexual intercourse with a child less than 14 years of age, amongst a variety of other crimes. So obviously my client has extensive concerns that mom is sharing pictures of their minor children and information about their family. I noted in her response that she tells this individual general information that she's going to practice for one of their children, and that she has shared pictures that are available on the internet. Obviously, my client is very concerned about this relationship. He knows he can't prevent it. I mean, that's mom's choice. I don't know if we will be asking for a mental health evaluation in the future, but certainly our concern is right now the best interest of the children, and quite frankly, my client, but lesser so, if she is providing information about their family to this individual. I'm concerned, based on her response, that she doesn't seem like this is a problem, and her ability to consider the best interests of the children with respect to this relationship. So my understanding is mom has agreed to a restraining order preventing her from providing information or pictures or anything about the children. I would ask that that include my client, because I don't know what this individual is capable of. I don't know when this relationship began. She says in late 2025, and I'm assuming she met him when she was working there in 2019. I don't know what is going on with mom at this particular point, that this is a relationship she wants to pursue, but certainly I think she needs to realize the impact this relationship can have on the best interests of these children. My understanding is that Mr. Lemons, this individual, does not get out of the correctional facility until 2036, but obviously those dates can change. I'm going to guess it's not based on good behavior, judging from his actions for disciplinary reports on him. But my client is certainly concerned about that. And he does have a little bit of concern about her ability to look at the best interest of the child when this is the relationship that she's choosing to pursue. But at the same time, he understands he can't control that. So that's our position today, Your Honor.
Very well. Thank you, Ms. Goheen. Ms. Sewer, what would your client's response be?
Yes, Your Honor. The proposed child support worksheet that Jennifer Goheen filed did not include the daycare expense, but I do acknowledge that I had her client's income a little bit wrong, so I did file a proposed worksheet which included the correct income with the court last week, and I do agree with her that I think we can work that out, assuming we get some direction on if we use a shared residency formula or not. With regards to the current court order, the order grants dad every other weekend and Tuesday evenings. The youngest child goes to Primrose, which is in Wichita, for daycare 3 days a week, Monday, Wednesday, Friday. The maternal grandma watches the child Thursday, and the paternal grandma watches the child on Tuesday. Since the filing of this action, the paternal grandmother has picked up the youngest one, Brooklyn, in the morning, which she's always done, and then picks up Baylor after school, and then dad meets up after work and then brings them home at 7:30. He's also been attending the children's sports events on other nights. So he gets to support them and see them on those events as well. And we're glad that he's doing that. So Monday, for example, Baylor has baseball practice. Brooklyn attends, and dad and my client have both been attending since the separation. Wednesday's track is starting. So there are other times that he is able to see the children in addition to the every other weekend and the Tuesday night. We filed granting my client primary residency because she works from home. And she has been the primary caregiver of the children throughout the marriage. Historically, when the kids have been sick, she's kept them home. She's picked them up from school. She has managed to work, and she works from home. So that gives her the capability of doing some of those things. She's done the majority of the doctor's appointments alone. She's one that gets the medicine. Even post-filing, there's been a couple of illnesses. And Dad did offer his mom to help on one occasion. But he himself hasn't offered or taken off time to help in those instances. She's been the one during the marriage to historically get the children ready for the day, with very rare exception. She did the majority of the bedtime and bath time routines by her estimate 90% of the time during the marriage. She's the one who regularly attended school functions, planned birthday parties, things of that nature. So we believe that the de facto arrangement is kind of reflected with the order that we filed with the court. In addition, the kids are well adjusted to their home in Rose Hill, where she's currently living with them. The neighborhood kids are over frequently. The kids have close relationships with their neighbors and other kids that they go to school with. Dad's parents live in the country. And so there's not a lot of neighbors, and we understand he's living there for now, and that's a good location for now, but we don't know where he's going to end up in the future. We don't know for 100% where my client will end up in the future. I know she's got some desires to keep the marital house, but that's still to be determined. I do acknowledge that prior to separation, Dad did deliver the youngest to daycare on his way to work on those 3 days a week. My client would get the oldest child ready, and he'd ride the bus from my client's house to school. Post-separation, my client has been able to deliver the youngest to daycare and get the older child on the bus because her schedule has more flexibility and allows her to do both, while Dad's doesn't. He's not available to take both to school or daycare. And my client is a little bit unsure with having his family members help. It's a pretty big burden, and we don't know if it's feasible long-term when he's not living in their home anymore. His motion notes his parents will help transport to school, but we're not sure how the oldest would get home, as the bus doesn't go to his parents' house. My client's schedule with working from home allows her the flexibility. In addition, the oldest son, Baylor, has about 8 weeks of school left, and he does have a history of struggling with changes and transitions. He's responded really well to the current schedule. My client let me know that his primary teacher will be gone for a full week in early April, and he's historically struggled with subs. So they've already put a plan in place with school to help with that transition that's going to be happening. And she's just concerned with another transition and then maybe doing domestic conciliation or the court making a different parenting plan in the future, and then there being another transition with a child that historically struggles more than the average child with transitions. The youngest child's going to be transitioning out of daycare, and I'm assuming attending Rose Hill or some school for the first time for pre-K coming up next school year. Dad's parenting plan, I don't know if it contemplates that Wednesdays there's a late start for the older son, so that probably complicates the drop off and the exchanges a little bit more. Not sure that he knew that or contemplated that. So our request at this point in time is for the court to leave the parenting time as ordered. The alternate weekends and the Tuesday is working very well. There's the option for additional time as agreed upon. There's certainly the option to go to activities that don't fall on his days as he's been doing. And I think this would be an appropriate case for domestic conciliation. Have the domestic conciliator work out and look at the logistics, the work schedules, transportation, activities, where dad might live, where mom might live, and come up with a detailed plan that's going to work. Collaborative Success has a great amount of success with mediating agreements. And they're also really good at detail and logistics, which I think would help these people. So that is what we're asking the court to do. I did file a response with regards to my clients having a relationship with someone that is incarcerated. My client's position is that that in no way hinders her ability to parent effectively and lovingly to these kids. We agreed in our response to not take the children to the correctional facility. We agreed that she wouldn't discuss any inmates with the children. Historically, the children haven't been involved with this person. They're not aware of any correspondence or any friendship that she has. The children have never visited the facility. She indicates to me that she doesn't share information with the children. She doesn't provide specifics about the children. She might very in general be like, I got to get off the phone. I'm going to basketball practice, but she doesn't say it's at the Y or it's at X, Y, or Z school or any specifics. So we are fine with the court entering a restraining order, whatever order that the court feels is appropriate. We're not denying or saying that this would be a good person to introduce the kids to or start having correspondence with. That's never been her position. I don't care if you include Mr. Benaway in that she won't talk about him either. I don't believe that she ever has. If I'd known that he had that concern, I would have stuck that into my response as well. But we do think that kind of restraining order isn't necessary because it hasn't been something that she has done or is wanting to do. But certainly we have no problem with that being entered as I indicated in my response. And I would say that, whatever order you make or whatever additional orders should stay in place long-term beyond this temporary order can also be something that's addressed in domestic conciliation. So that is what we are asking the court to do, leave the parenting plan in place and order domestic conciliation to develop a long-term plan.
There are a couple of questions. Was Brian Benaway consulted regarding the terms of the original parenting plan and the temporary order?
No.
Was Ms. Goheen consulted, and did she have input into the terms of the original temporary order?
She was not retained at that point in time, so no.
I suspected as much, counsel.
Yeah.
Counsel, a temporary order is a stopgap measure. It's only meant to keep things steady until the matter can come to court. The court's had an opportunity to hear from both sides in this case. And Mr. Benaway has a very reasonable plan that he submitted to the court, which essentially would keep him equally involved with not only equal rights, but equal responsibility for these kids, despite some other logistical problems that the separation has caused. After all, the court takes into account, Ms. Sewer, that it's your client that filed the declaration of war in this case, a divorce petition, which basically says we're going to end our marriage and things are going to change. Realistically, they're going to change for the children as well. But the court at this juncture wants to see both parents equally involved and with equal responsibilities. This court will adopt the father's temporary parenting plan in this case as a shared residential custody arrangement. I do understand that there is going to be some changes in the daily routines of the children, different ways that they're transported from point A to point B. However, Mr. Benaway appears to have the resources in place to be able to cover his end of things. And obviously the mother is covering her end of things as well. And this court has no issue with grandparents doing transports. In fact, I can't think of any people that have a bigger stake in keeping things normal for these children than grandparents do, except for the parents themselves. So obviously the court encourages their involvement at this point. Mr. Benaway, just some direction that the court would like to give here. If you're going to live in the Augusta area and you have a child that's in Rose Hill, this court will expect that there's not going to be tardies and there's not going to be unexcused absences caused by some logistical distance problem that you have on your end. In other words, the court's just asking you to make it work.
Yes, sir.
Further, as far as long-term concerns are concerned, you should at least think that if the children are going to be in Rose Hill schools, and I do understand that you've already got one in the Rose Hill school system, you need to live closer rather than further away as far as a long-term residence is concerned. I'm not going to tell you where to live, but shared custody arrangements work best when the parents live in close proximity.
Yes, sir.
Augusta is close enough at this juncture. Long-term, the court wonders if that's a truly workable situation for the kids in the long term. Further, this court will enter an order that the mother in this case is not to share any pictures, video or audio recordings, or any other information regarding her children with any prison inmate, nor any information regarding Brian Benaway. Further, she's not to discuss any inmate business with the children under any circumstances. This court does have a concern about this relationship, if you will, if that's truly consistent with the best interest of the children involved. But at this point, it would appear that the mother's doing what she can to keep that separate. And the court's orders are meant to be a clear court directive that those things be kept separate. Obviously, the child support worksheet in this case, once tweaked as far as all of the numbers for input purposes, will be a shared custody worksheet, quite obviously. Ms. Goheen, you're going to have the responsibility of drafting this amended parenting plan order. I don't know who's going to be taking the responsibility for the child support worksheet. Ms. Goheen, will you be doing that as well?
Yes, I can do that.
Okay, and include the new child support order in your journal entry, which stems from today. As far as the effective date for the new arrangement, I think who would have the children starting Wednesday morning? Under your plan, Ms. Goheen. Separate periods, but not.
Having the kids Monday until Wednesday at 8.
All right. Yeah. Then his time will start next week.
That's perfect, Judge.
We'll go with that plan. And then whose weekend would it be this weekend?
Brian?
That would normally be my weekend this weekend.
Okay.
All right.
It should be his weekend.
Okay. So his parenting time will then start at the beginning of weekend time, which I think is Friday at 8. And he'll go into his shared custody parenting time period early next week. Again, this is a temporary order to see if it works. It very well may be the basis for a long-term order, and sometimes it is, and sometimes it isn't. Your thoughts regarding domestic conciliation, Ms. Goheen?
I am fine with domestic conciliation if mom wants to pursue that after today's hearing. And I'll work with Ms. Sir if mom wants to tweak this parenting plan at all in terms of time. We do want to work with mom and Ms. Sir on that. But if she wants to pursue domestic conciliation, Judge, that's fine. I would object to using the facility that Ms. Sir had suggested, but I think that Ms. Sir and I can come up with an agreeable individual to do domestic conciliation.
Do you agree with that statement, Ms. Sir?
I would think that we would be able to agree to someone.
Okay, I have had to resolve disputes between attorneys before regarding the choice of a domestic conciliator, and I would rather not. Though I think there are a number in the Wichita metro area which this court would be comfortable with. So I'm sure whatever choice you make, counsel, this court will be perfectly fine with. The court will order the parties to participate in good faith in domestic conciliation with the idea of we're just working out a long-term parenting plan that's good for your kids and in their best interests. Finally, I did want to make a comment. I guess it really applies to both parties, but perhaps more to Mr. Benaway. There are times you may need to use the mother as a resource that's technically not her time. She is an excellent resource for your kids, maybe the best resource. If there's some reason why it doesn't work for your side of the family to be able to take care of something, perhaps the mother should be kept in mind as the resource that you go to next, and not try to exclude her because somehow you see that as she's getting an advantage in the case by having slightly more time than you. Ultimately, then, I think that really facilitates the best interest of your kids, especially kids that are 7 and 4. So I ask the parties to use each other as a resource when you need to.
Yes, sir. Thank you.
All right. I'm looking at my notes here, Ms. Goheen. Was there any other ruling that you were seeking from the court at this juncture?
No, Your Honor.
All right, Ms. Stewart, is there anything today which you need clarification on?
I do not believe so.
It was stated at the beginning of this hearing that the parents communicate well and generally work together well. I hope that that continues, and I give you both credit for any cooperation that you do as parents, that when you work together for the best interests of your kids deserve that kind of cooperation. So I would just say keep it up. All right. If there's nothing further at this time, then the Benaway matter will currently be in recess, and this meeting may be ended for all at this time.
Thank you, Judge.
Oh, excellent. Reseat yourself. Yeah, come on up. Yeah, sorry about that. And who is this? This is Mr. Newman. And what's going on? Oh, nothing. He's just having some blood sugar issues. And so he's just wanting to get hurt. So so what we're doing here, so he's got a couple matters, a compliance matter and a protection order violation. And we've come up with a solution here. That being is he's going to enter on the pretrial matter ending in 1154. He's going to enter a guilty plea to the amended charge of disorderly conduct. All right, this is City of Yonge versus Samuel Newman, cause number 4A07454001 and 5A0001154. We are on for pretrial on the 154 matter and a compliance on the diversion for 401. So why don't we deal with the diversion situation first? That's a protection order violation. Go ahead and sign here. So what I think the parties were prepared to do here was upon the court's acceptance of the plea to the amended charge of disorderly conduct, then the parties would stipulate that as to the compliance matter, that's a violation. So the SOC be yeah, correct. Okay, all right. Yeah. All right, so then we'll deal with the 154 cause number first. Right. All right, and you are Samuel Newman? All right, Mr. Newman, I have before me a statement of defendant on plea of guilty. What was your last level of education completed? Okay. All right, and I have the original charge of protection order violation, city moving to amend to disorderly conduct?
That's correct, Your Honor.
Okay. And Mr. Newman, did you have a chance to go over this form with Mr. Haverco? Okay, did he read it to you or do you read it yourself? Okay, did you feel like you had enough time for him to answer all your questions?
Yeah.
I know, Mr. Newman, but listen, you're not going to run this show here. I'm trying to get through it, so I want you to listen to Mr. Haverco. I'm going to go through certain things with this. The quicker we can get through this, the easier it is for it to do this, okay? I understand. So
Okay, that's fine.
okay.
You can't say it before.
Are we ready to go? Okay. Mr. Haverco, we're ready to go?
I think so.
Okay, all right. So the amended charge is disorderly conduct, and Mr. Newman, that's a misdemeanor. Means maximum penalty is 90 days in jail, $1,000 fine. There's a recommendation contained in this plea form that I don't necessarily have to follow. I could sentence you up to the maximum. And you understand by pleading guilty, you're giving up a number of constitutional rights? Okay. And at paragraph 11, there's a statement that's written there. And you're making a plea pursuant to an Alford plea, and it's in re bar. So what I will do is I will just take a look at the police reports and then see what we've got, and then I can determine if the facts are sufficient to support the charge. And it's in re bar, which loosely means it's giving me some flexibility, understanding that it may not fit entirely, but you're taking advantage of an offer. Okay, so give me just 1 second. All right, based on the nature of the plea, the Alfred plea in relation to in-rate bar, I will find, based on the agreement of the parties, sufficient factual basis for the amended charge of disorderly conduct. So I will enter a plea of guilty or make a finding of plea of guilty to that charge. Are we moving to sentencing today, Mr. Radfield? Okay. Anything else from the city? All right, Mr. Haverko?
Nothing to add, Your Honor.
All right, Mr. Newman, this is your opportunity to say something, to explain.
Say my daughter, she called me, she was having that need, so if I have to move, she'll feed my child, I have to take that to parent. Just bring them something.
Okay,
And it will wait.
gotcha. Okay. Okay, and the police reports say a little something different than that.
Well, they said I haven't done enough.
Yeah, yeah, I got it. No, I think that's probably pretty clear based on the resolution. Okay, all right, so what I'm going to do is on the judgment and sentence, Mr. Newman, I'm going to follow the recommendation. I'm going to impose 90 days in jail, suspend all 90 days, impose $1,000 fine, suspend all $1,000 for a period of 12 months, maintain law-abiding behavior. You're going to pay a probation fee of $250. No criminal law violations. Okay. I'll go ahead and sign this order. And then on the order on review of revocation under the previous no contact order violation, my understanding the parties agree that this new charge constitutes a violation and would result in revocation?
Yes.
And is it a revoke and close? Okay. So, Mr. Newman, based on the new charge, the protection order violation that you were on for compliance review, simply the stipulated order of continuance is going to be revoked per agreement of the parties, and a finding of guilty will be entered, but then the case will be closed. Okay.
One more signature.
Yeah, go. And you'll enter the plea of guilty will be, or the finding of guilty will be entered? Okay.
Yes.
Okay. All right, Mr. Newman, I've signed that order, so you can pick up copies of them at the window, and I wish you good luck. Yep.
And the last matter that corresponds to someone who's here is on the 10 o'clock calendar. Mr. Tipton was late. I don't remember what time he got here, but he wasn't here for the calendar at 10 o'clock.
All right, good morning or good afternoon, Mr. Tipton. How late were you? That's it? I think it might be more like 45 minutes late. Yeah, okay. But you were late, so obviously we prefer you to be at court on time. What are we doing with Mr. Tipton's matters?
Well, one of the things that it's getting a little frustrating for me. I've made notes on his 4A case, the one that starts with 4A.
Yep.
Okay.
There's actually 3 of them that start with 4A.
Oh, okay. So I guess I made the notes on the one ending in 275. So just for the court's information, on 221-25, 224-25, 417-25, 613-25, 724-25, 1726, 112-26. I've called him. He has never called me back. And then he arrives late, and then we wind up resetting it. So we're sort of in this endless spin cycle. So I don't know how to. You guys, my mom. What's that? I give you guys my mom. I have called a number that you've given me numerous times. So I'm not prepared today, so I don't know what we're doing. And so I guess I would have to ask to reset. But again, if he keeps showing up late, and he doesn't answer my calls, then we're just going to keep doing this, I guess, in perpetuity.
That's the case, Your Honor. City's going to ask.
Okay. So these cases are from July. Well,
We have some.
and their compliance issues. We have new law violations. Yeah.
Pretrial from, or ones from December 2024.
Okay. So Mr. Tipton, what I'm going to do is this. I mean, you were late today. These cases, you're on compliance for diversions from 2024. We have new law violations from December of 2024. We have new law violation from July of 2025. Late today, Mr. Haverco, it sounds like, has made multiple attempts to get a hold of you. What I'm going to do is on the on cause number, based on violations of the conditions of release under 4A0901275, I'm going to impose a bail amount of $1,000 cash or bond. Okay? You're going to be able to post that. Okay. What I'm going to do is we're going to post a bond of on the 275, $1,000 cash or bond. I'm going to set this for 2 weeks. I know we're getting.
That's okay. It was just the 9 o'clock.
Okay. So I'm going to impose $1,000 cash or bond, which you're going to be taken into custody until you post. Okay. If you post, your next court date is going to be in 2 weeks, which is going to be March 26th. I want you here on time. I want you to be in contact with Mr. Haverco. He's in the book. You can find him. If you haven't heard from him, you say, Mr. Haverco, why haven't you called me? Right? Okay, you haven't done that, but we're going to move this case forward one way or the other. Okay? So it's either going to be with you in custody the next 2 weeks, or you can post, which then puts some, gives you some skin in the game, because you are costing the court a ton of time and a ton of time and a ton of time. So, I'm sorry? Okay. Well, what we're going to do is we're going to take you in on the $1,000 cash or bond today. And if you post, we'll see it. Either way, we're going to see you back here on March 26th. Okay? And that'll be all for today. Thank you, officer. So I've got
We have some no-shows. Not a lot.
okay, we just do it. Just I got a meeting at noon. Go ahead.
Okay.
Okay.
Did we, so Mr. Michael Heelan didn't appear, and I don't have any information.
Okay. Cause number 5A0932945. Michael Heelan, no response. Malicious mischief, third degree. What's the city's thoughts?
City likes to take more issue.
500 cash or bond, please. Zachary Sawaya, sorry. All right, Mr. Sawaya is present. Out of custody, cause number 6A0021975. Mr. Haverco.
Are you looking at it? Taking $850 a month on unemployment.
Find him eligible for court-appointed counsel at no cost to him.
Stipulate probable cause, ask the court to enter not guilty, please.
Okay, find probable cause, purposes of this hearing only as to both charges, and enter pleas of not guilty. Hear from the condition, or from the city in terms of conditions for release. All right, so I'm looking at Mr. Sawaya's history here. He has a protection order violation out of Puyallup, May of 2025. Violation of protection order out of Yelm, May 30th, 2025. Protection order violation, August 7th, 2025 out of Yelm. And then we have malicious mischief third, January 6th, 2026. And assault fourth degree, violation of harassment order, no contact order on February 27th of 2026. All right, I'll hear from you, Mr. Haverco, but I'm going to tell you I'm inclined to take Mr. Sawaya, hold him on some bail.
because this is a theme developing in the last 8 months. So any thoughts? What is the court? Well, I'm inclined to impose $5,000 cash or bond here. Under the circumstances, there's multiple violations. I don't know if they're the same order, but they're the same sort of theme. We have a pending malicious mischief third in this court. So he's on conditions for that. So I'm inclined to impose a $5,000 cash or bond on this. I just wanted to check. Oh, it doesn't list. I was looking in jabs just to see if there was a theme as to the victim, but it's not always listed. Right. I looked at that as well. Well, I mean, what's it? Are you in a situation where you're likely to have contact?
No, no, because he ended up moving into our house when the whole altercation that happened on Friday. I moved into my dad's house all the way up in Puyallup.
Okay.
So I'm
See your brother?
Yes, that's my older brother. So I'm currently not even living in Yelm anymore. I moved to Puyallup.
Well, I guess I don't, there's no argument to redress the court's concern about the history because it is what it is. As far as the current matter, he advises he's based on this conflict. I guess it's his brother. He's moved in with his dad in Puyallup. So at least for purposes of the pending matter, it would appear that circumstances help minimize any risk of public safety in this case. But again, I can't refute the court's concern about the history because it is what it is. All right. So Mr. Sawaya, what I'm going to do is this. I'm going to hold you on $5,000 cash or bond. I think you are a risk to continue to commit crimes. I mean, again, I'm looking at your history, and again, since May of 2025, we have protection order violation, protection order violation, protection order violation. You have a pending malicious mischief from January of 2026 in Yelm that you were on conditions for. And then now, a month and a half later, we have a new charge. And again, I realize they're just charges, but new charge of assault fourth degree and a violation of harassment, no contact order. So I'm going to hold you on $5,000 cash or bond. Do we think Mr. Sawaya is going to be able to post? Okay. If you post, or if you don't post, your next court date is going to be March 26th at 8:30 a.m. Again, I want you here, even if you post, I want you here at 8:30 a.m. on March 26th, and then we can deal with how to proceed with that. In the interim, if you do post, you're to appear timely at all court hearings. You're to have no criminal law violations. Keep your address and name and everything up to speed with Department of Licensing and the court. Not to have any contact with or go onto the property of Blake Sawaya, and you to abide by all no contact orders. Okay. Okay, so I'm going to turn you over to the custody of the officer, and then we'll see you back here on the 26th. I'm waiting to sign the order. Go ahead and sign on here. Okay, he's done. All right. I'll sign the order.
Oh, that's all we got right now. But, ladies and gentlemen, do not let your heart be troubled. in just a little under about 7 hours from now, we're going to have a premiere with live chat and everything. And it's a follow-up to a crazy Hesselink case that we've seen before with a very well-off couple and a guy who likes to stalk his ex-wife from the bushes and get caught by the cops. And it's just a whole mess, guys. It's a little over an hour long, right at an hour. But yeah, it's the same time we normally stream every weeknight. That would be 8 p.m. Central Time, 9 p.m. Eastern Time. Come on back by. We'll be hanging out, chat, talking about the craziness going on in Hesselink's court. That's all I got for today, ladies and gentlemen. Thank you so much for hanging out with me. All of these court cases have been a pleasure to view with you and comment on, and man, chat, you're just all the best. Here, Granny, Julie, Rhonda, Mama, Math Girl, Northwest, Mama Pet, Meow Kitty, wherever Meow Kitty is, Felix, all you people. Oh my God, Barry is coming out with a, oh my God, I don't have the thing set up. Look at me, I'm horrible. What's going on? Why is this doing like that? Hey, look at that. We'll give Barry a big heart. Thank you so much, Barry. You rock. I not only owe you a great big thank you, but I also owe Zach a great big thank you, and everybody, Law Nerds Unite. Don't forget about Law Nerds Unite, our friend. Wow, what else can I say? I'm your Lone Wolf Foosel. I'm your curator for these here videos. I'm the crazy guy who puts together all of these little compilations, compiles them into a little archive, and sticks them here so you can take them in at your own speed and need. Thank you, Larry. Thank you, Mortimer. Thank you, One Break. I don't know how to say your name. I'm sorry. It's the best I can do. It was a good try, though. I love all you guys. I'll see you tonight, chat, probably. I'll probably be hanging out with some friends, too. But hey, we're doing a little bit of everything, right? The case we have tonight does have a little custom, and it is an AI song, but it is a satire parody, not intended for soul. For funny, for fun. Guys, thank you so much. I'm your Lone Wolf Foosel. You're all the bestest. I couldn't ask for more. We'll see you next time. All right, out. And remember, when life gives you lemons, squirt someone in the eye.